explain the topic general exceptions under the Bharatiya nyay sanhita. First of all, what is a general exception? A general exception is a legal defense. It means that even if a person is committed any act that appears to be an offense, the law may excuse that person because of the circumstances in which the act was done. In other words, the act is not treated as crime if it falls within one of those general exceptions provided in the BNS. The purpose of these exceptions is to ensure that innocent people or people acting under circumstances are not punished unfairly. The main general exceptions under the BNS include mistake of fact, judicial acts, accident, necessity, infancy, unsoundness of mind, intoxication, consent, communication made in good faith, tribal acts, right of private defense. So first we are going to start with the topic judicial act. So one of the judicial act section number 14 is act done by a person bound or by mistake of fact believing himself bound by law. Nothing is an offense which is done by a person who is or who by reason of mistake of fact and not by mistake of law in good faith believes himself to be bound by law to do it. For example, a soldier fires on a mob by the order of his superior officer in conformity with the commands of the law. A has committed no offense. A. An officer of a court being ordered by the court to arrest Y and after due inquiry believing Z to be Y arrests Z. A has committed no offense. So in this section there are two perceptions. The one of the perception is that a person who is holding an authority, say for instance the authority of holding a gun. Authority of holding a gun is act done by a person bound, means he is bound by the law to hold that gun, means normal people cannot be able to hold that gun, but the person, for example a supreme or for example an officer, a soldier can definitely hold the gun, or by mistake of fact believing himself bound by law. So in the case where the soldier is firing a mob by the order of his superior officer in conformity with the commands of law, he has committed no offense, means because he is having an authority to fire on the mob, while an officer of a court being ordered by the court to arrest Y and after due inquiry believing Z to be Y arrests Z, A has committed no offense. So over here we can see that over here he is also having an authority, but over here he is doing a mistake of fact, mistakenly he arrests another person, so it is not a mistake as he did it with a good intention. Now we come to section 15 where the act of a judge when acting judicially. So nothing is an offense which is done by a judge when acting judicially in the exercise of any power which in good faith he believes to be given to him by law. For example, a person is a judge and he is acting judicially and he have an authority to give a judgment. So if he have a judgment to punish anyone, so definitely he is making to ensure justice, right? So that is not an offense. Act done pursuant to judgment or order of court. So nothing which is done in pursuance of or which is warranted by the judgment or order of a court, if done whilst such judgment or order remains in force, in an offense. Notwithstanding, the court may have had no jurisdiction to pass such judgment or order provided the person doing the act in good faith believes that the court has such jurisdiction. So for example, the act which is in accordance with the judgment or order of the court or which is warranted by the judgment or order of a court, if done opposite to that judgment, whether the order remains in force, is an offense, but notwithstanding the court may had no jurisdiction. For example, I would say कि a person who is in accordance of law is a police officer and he is been advised or has been authorized to arrest a person, but unfortunately or accidentally or mistakenly he arrests another person who had no jurisdiction, means he had not committed, he is an innocent person. So Over here, notwithstanding, the court may have had no jurisdiction to pass a judgment or order, and the person is also not having any kind of liability to be arrested, provided that the person doing the act in good faith believes that the court had such jurisdiction. Now we come to section 70. Act judged by a person justified or by mistake of fact believing himself justified by law. So nothing is an offense which is done by a person who is justified by law, or who by mistake of mistake of fact and not by reason of mistake of law in good faith believes himself to be justified by law in doing it. For example, A sees Z commit what appears to A to be a murder. A, in the exercise to the best of his judgment exerted in good faith of the power which the law gives to all persons of apprehending murderers in the fact, seizes Z in order to bring Z before the proper authorities. A has committed no offense, though it may turn that Z was acting in self-defense. Now we come to section 18. So what is section 18 is saying? It's the accident in doing a lawful act. For example, A is at work with a hatchet. The head flies off and kills a man who is standing by. Here, if there was no want of proper caution on the part of A, his act is excusable and not an offense. Thus it is not an offense which is done by an accident and without any criminal intention or knowledge, in which doing of the lawful act in a lawful manner by lawful means and with proper care and caution. Now we come to section 19. So what is section 19 saying? Section 19 is saying that nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm, if it be done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm to person or property. For example, a person is riding a bicycle and he sees that there is a possibility that he can definitely accident with a child. So in order to prevent himself from not doing it, so he turns his bicycle and he leads to commit an accident of an animal which is definitely excusable. So in order to avoid the high evil, he is committing a very small offense, so it is a necessity. So and he is also not having the criminal intention, which is the most important thing and the factor affecting in this case. So from here we can conclude that nothing is an offense merely by reason of its being done with the knowledge that is likely to cause harm, if it be done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm to person or property. So we come to section number 20. Act of a child under 7 years of age. So it is not an offense which is done by a child under 7 years of age, which is known as the absolute immunity, and in Latin word we say it as dolly in capax. Now we come to section 21. Now a child who is above 7 but under 12 years of age is usually having an immature understanding, but it is also not an offense which is done a child above 7 years of age and under 12 years of age who has not attained sufficient maturity or of understanding to judge of the nature of the consequences of his conduct on that occasion. So there are basically two perceptions of this case. One person who is below 12 years of age and not having the maturity and not having the enough maturity, so he will be excused. But the person who is below 12 years of age is having the maturity will be punished, and this whole case is known, and this section 21 is known as the qualified immunity. Now the act of a person of unsound mind. Nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act, or that he is doing that what is either wrong or contrary to law. So for example, a person who is having a split personality or a bipolar disorder, so he commits a crime and he is, by the reason of his unsoundness of mind, he is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. that person will be excused as he is having an unsoundness of mind. So we come to section 23. Act of a person incapable of judgment by reason of intoxication caused against his will. Nothing is an offense which is done by a person who at the time of doing it is by reason of intoxication capable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. For example, a person is intoxicated and he is intoxicated against his will. Means a person is having a cup of juice in which his acquainted person or his belonged person adds a few drops of intoxication such as drugs, alcohol, any kind of drug item in it, and he just advises him to have it, and he literally had it. So it is an offense. It is an offense of the person who is making it do so. It is not the person's offense who is bona fide over here and who is consuming it without knowing it. So, for example, is by the reason of intoxication incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided the thing which intoxicated him was administered to him without his knowledge or against his will. So over here the person is not liable under the law, under the Bharatiya nyay sanhita. He is excused with the general exceptions, as there is no fault of him. The fault of the person is who is making him drink and nobody else. Now, offense requiring a particular intent or knowledge committed by one who is intoxicated means offense means a person who is having a particular intent and is also having a knowledge that I am drunk and I am able to control myself, but then also he commits a crime. So a person who doesn't act in the state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge or against his will. So now we come to section 25. Act not intended and not known to be likely to cause death or grievous hurt done by consent. So this is a facet of the voluntary non-fit injuria. So nothing which is not intended to cause death or grievous hurt and which is not known by the doer to be likely to cause death or grievous hurt is an offense by reason of any harm which it may cause or intended to be doer to cause to any person above 18 years of age. For example, A and Z agrees to fence with each other for amusement. The agreement implies that the consent of each to suffer any harm which in the course of fencing may be caused with foul play. Means they are doing something immoral. So in between of the immoral activity, in between, if there is a conflict between both the persons, the law cannot take any kind of side of the person because they both are the wrongdoers in this case. Now we come to section 26. Act not intended to cause death done by the consent in good faith for person's benefit. Nothing which is not intended to cause death is an offense by reason of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to any person for whose benefit it is done in good faith, or who has given a consent whether expressed or implied to suffer that harm or to take the risk of their harm. Means a person is a surgeon without knowing that the particular operation is likely to cause the death of Z who suffers under the painful complaint, but not intending to cause Z's death and intending in good faith Z's benefit perform that operation on Z with Z's consent, A has committed no offense. Means, for example, A is a surgeon over here, and knowing that a particular operation is likely to cause the death of Z who suffers under the painful complaint, but not intending to cause Z's death and intending in good faith Z's benefit performs that operation on Z with Z's consent, A has committed no offense. Now we come to section 27. act done in good faith for benefit of child or person of unsound mind or with the consent of guardian. For example, a person is in good faith for the benefit of a child or a person of a unsound mind or by consent of a guardian. Means, for example, a person is giving a consent to his child's uncle to operate his his stone which is being in his gallbladder. So if he is operating him, but the operation causes death of the person, so over here there is no cause of, it is not an offense of the person who commits the who basically does the operation of the person, yeah, because he is in good faith.